So welcome to Trent University, and thank you for joining us this morning for our panel discussion on your estate matters, presented by the Peterborough Estate Planning Council.
This isn't all of us.
It might feel like that. My name is Sherry Booth, and I'm the Senior Development Officer for the University, and I'm also the incoming President for the Estate Planning Council. The role of the Council is to share current and relevant and important estate information with the Peterborough community. And we've gathered this panel here of experts who are going to share their collective and cumulative knowledge and hopefully answer any questions you might have and walk you through some of the pitfalls and places you should be making sure you've got covered in your estate planning. The panel discussion is going to run for about an hour and a half. We're having each presenter speak for about 15 minutes, and then we'll have a question and answer after each of them. And I'm going to be trying to rope them in and make sure they're not going too long. So that's my role here today. And I'll just introduce the panel first initially, just one time over, and then I'll introduce them a little more when they're going to speak. So we have our lawyer, Peter Lillico, our accountant, Stephen Bark, our two financial planners, Gord Fallen and Linda O'Connor, and our legacy expert from the hospital, Jennifer Curitin. So, to start, we'll begin with Peter. He's going to talk about legal matters. Peter is a local lawyer. Many of you would know him. He's a partner at the firm Lillico, Kent Galloway. And Peter's also a past president of the Estate Planning Council, as well as the Peterborough Law Society. He's author of the Estate Planning Toolkit for Business Owners. He's also an expert. We've had him speak many times on cottage succession planning, because that's a bit of a trip point in estates. He's a humanist officiant, and as well, one of his sparkly personality traits and talents is that he's also a firework display organizer. So I don't know if you're any of you...
That's my most fun job.
And it is worth it, by the way.
He was at the opening ceremony for the Christian Chu Stadium and did our fireworks for us. So I appreciate being able to call on Peter's many talents.
All right, thanks, Sharon. So some of you I know are here because of the senior showcase presentations that the Estate Planning Council did a week ago today. And my talk up there, of course, we only had, 5 minutes or something like that each. And it was exclusively on wills. To my mind, there are three critically important legal protective documents: will, a power of attorney for property, and a power of attorney for personal care. So in the 15 minutes allotted to me, I'm going to try to spend 5 minutes on each of those to update you on what they are and find out if you have them, and if you haven't, give you recommendations on what you should look for in that regard. So briefly, I'm going to talk then about wills first. How many people here already have wills? That would be almost everybody. How many people here are sure that they have reviewed and updated your will within the last 3 years? Only one. Okay, so it's very important to have a will. I was going to lecture everybody and scold you if you didn't have one about what a disservice you're doing to your loved ones if you don't have it, and I won't go into that because you already have wills. Instead, I'm going to let you know that if you have, as the professionals will certainly tell you, an obsolete will can be almost as bad as, if not worse in some cases, than having no will at all. And so many people will have done a will, and they'll have done it some years ago, and it's like they ticked off a box and they said, good, I've got a will, I'm good to go. Just like I've got the brakes done on my car and I never need to worry about brakes again. And it's just not true. You do need to be concerned about your will. The review recommendations that I invariably provide to my clients are: pick some memorable day each year. Now, wills, as I say, they don't have a best before date. It's not like your driver's license, where every 2 years you've got to pay to get a new one. That's not true. They will continue to go. There are terminating events, and one of the terminating events that catches people out, this is part of my humanist officiant marrying people, is if you get married, your will is automatically terminated. So there are lots of people who have a will and may get married late in life, and the husband and wife may both agree, well, you're leaving everything to your kids, I'm leaving everything to my kids, we're both good with that, we'll just keep our wills, we'll save on the legal fees. In fact, what they have done as soon as they get married is both of their wills are terminated, whichever one dies first then gets a spousal preferential share, and we have a sorry legacy indeed. But in most cases, people's wills do not automatically expire, but they can become obsolete. And they can be obsolete because of changes to your family circumstances. It may be you've had grandchildren, since I've done my will initially and I want to involve the grandchildren, or even worse, I was so excited when I had my first grandchild, I wrote that grandchild into my will, and since then I've had 2 or 3 and haven't remembered to plug them in. It could be people that you were involved with, say as your executor. The executor may have moved to a different country or be in poor health, and so when the time comes for them to do their job, they may not be the most appropriate people. Your financial circumstances may have changed, better or worse. That may have an impact on the will. And there's new legislation that comes into effect. So there are a lot of reasons why wills can become out of date. And so my recommendation to you, to all of you is, see if you can find your will today and read it over. That's it. But my recommendation going forward is to pick some memorable day each year. It helps if it's like your anniversary, or as Steve Park likes to say, April Fool's Day, or as I like to say, Canada Day. So when you hear the fireworks go off, it reminds you, I got to just read over my will. Now you're not reading it over to analyze the protections built in for children who suffer the consequences of a divorce after you're married. I mean, not or after you passed away. That's not the level that you're looking at. You're just reading it over to see what jumps out at you. And if something does jump out at you, oh, like my executor's son is now working down in the States and will be down there for some years, I wonder if that's a problem, then call your lawyer. And let it be your lawyer's responsibility to say, no, John, it's fine the way it is, we have adequate backups, keep your wallet in your pocket, or please come in. That is not something we anticipated when you did your will 4 years ago, and it could be an issue, and we need to put our thinking caps on. Most years that people look at their wills, they are not going to have these things jump out at you, and therefore you'll just tuck them away again until your next anniversary or until the next Canada Day. But then every 3rd year, as I recommend to my clients, even though it may seem fine to you, you don't tuck it away, you call me and you set up an appointment. And we get back together and we go over every aspect of your will planning. How are you and where are you living, and what about your spouse, and are your children still in the country, and what about health, and have there been grandchildren, and have your assets changed, and are there new legal aspects that we can import into your will to improve it. In my situation with my clients, I don't charge them for the reviews. It's only if we end up making changes. Your lawyer may have a different policy, but it's well worth it to spend whatever, $100, a couple of $100 every 3 years to be sure that your will is just as good as it possibly can be. One of the most serious parts about the wills and the powers of attorneys that I'm going to speak to you about next is, almost by definition, they have to be up, running, and perfect when you need them. When you're dead, it's too late to say, gee, I wish I had remembered to update my will. If you become mentally incapable and the government and courts step in, oh gee, I wish I had put a new attorney in to my property power of attorney. If you're in the emergency room at PRHC and your people that you want to have authorized to consent for you aren't available because they're out of the country, it's again too late to do anything. So to have a thorough review every 3rd year is only intelligent and prudent. Okay, so that's all I'm going to say about your wills. Have them, review them today, and if there's any question today, call your lawyer and just say, is this an issue? If they seem fine today, then when you tuck them away again, make your own little promise to yourself, it's anniversary, it's birthday, it's Canada Day, write on the envelope, whatever, 2016. And that will remind you, if you are in the routine, oh, 3 years has gone by again, now it's absolutely time to go in and see my lawyer. And I would recommend to you, if you look at your will, it's a little bit of a shudder because holy cow, it's 2004 and I was pretty sure it was 2008, then I suggest you make an appointment with your lawyer to go in and do the same type of thorough review that I have mentioned. And the worst that can happen is you walk away saying, hey, everything is as good as it possibly can be, and you've reset the clock for 3 years. And I suppose the best in another way is you find that there's an issue in the will that perhaps you didn't know about, and it can be addressed now and corrected now so that it's not going to be a big problem in the future. Now, powers of attorneys. How much time have I got? I'm okay. Powers of attorneys. There are actually two types of powers of attorneys. Actually, there's lots of types. There's two main types that I'm going to speak to you about today. One is power of attorney for property, which I don't like the terminology because people think property and they think real estate and they think I'm in an apartment so I don't need one. But powers of attorneys for property are documents that authorize somebody to act on your behalf for legal and financial matters. Anything that requires a signature, whether it's operating a bank account, whether it's signing a deed, whether it's signing a lease, whether it's filing a tax return, whether it's renewing an investment, whatever it might be that requires a signature, the power of attorney for property, you're authorizing somebody to act on your behalf. I stress that signing a power of attorney for property takes nothing away from you. It doesn't say I can't do my checks anymore or somebody else is authorized. You're sharing your authority, you're sharing the ability with somebody else. And I'll come back to that point because it's important to provide a structure that says just when that authority is to be shared. The other type is the power of attorney for personal care, sometimes erroneously referred to as a health care directive, sometimes erroneously referred to as a living will, but I'll come back to that later. It deals with consenting to medical treatment, residential decisions if you're not able to make them. But the powers of attorney for property, there's a couple of different reasons why you might have a power of attorney for property, and a simple one might be simply convenience. Perhaps I'm laid up and I've had a hip operation and it's not easy for me to get to the bank, but nevertheless I need to get my statements, I have checks that I need to deposit, I want to move some money around and I'm not online. So with a banking power of attorney, a limited banking power of attorney, well, any type of a power of attorney for property that works in that way, you can simply whistle up your kid and say, hey, listen, on your way home from work, would you please stop by the bank and would you withdraw $100 for me and would you please pick up a statement, something like that, and people would be authorized to do it. Other times when it may be convenient, or anybody here a snowbird out of the country for a month or more? So having a power of attorney that's triggered into operation while you're down south for a couple of months, if there's an ice storm and a tree falls on the roof of your house, and then you've got somebody up here authorized to deal with the contractors, deal with the insurance company, deal with all the things that need to be done. You can tell them what to do by phone, but you don't need to come up to sign the documents. So convenience is one aspect of it. I'm not really concerned about the convenience part of the power of attorney for property. I'm most concerned about the risk management part of the powers of attorney for property. What a lot of people don't realize, we all hope and aspire that we will retain our full mental capacity right until the day that we die. But for a lot of people, there will be at least a period when they're not mentally capable. It could be permanent if somebody gets Alzheimer's and doesn't recover, but the first 80 years of their life might have been fine. It could be a short-term incapacity because of a slip and fall, a car accident. It could be maybe the better part of a year if somebody's had a stroke and they have to recover. But regardless of the causation of the root cause of the loss of capacity, the legal consequence is the same. It is not automatically your spouse or your adult next of kin that step in and take over your financial affairs. It is the provincial government in the form of the Office of the Public Guardian and Trustee. How many people would like the provincial government to run their financial affairs? Right. And so the power of attorney for property then is your main shield against government or court involvement if there's a time when you're mentally incapable. And as we were saying to somebody earlier, you don't choose these times, right? You wake up and you've had a stroke or whatever. It's not something that you can say, well, I think I'll schedule my health issue for 2 weeks from now, and that'll give me lots of time to get to the lawyer. You have to have it in place now. So that's one of the most important things that the power of attorney for property does, is if you need it, if you are truly incapable, you are in the hospital, you've had your stroke, the healthcare team will automatically notify the public guardian and trustee that you're not mentally capable, and they will come knocking. And if your spouse, say, has a document called a power of attorney for property to say, hey, there's no room for you guys to come in the door, I'm already an authorized person and I agree to act, and they'll say, fine, we'll go back to Toronto, we'll mind our own business there, we'll find somebody else to help. If you don't have that, then they're there and in your face, and it just compounds the problems that you and your spouse and your family have. Attorneys, who are the attorneys? This one is why you want to have a lawyer to help you do a power of attorney document, because the choice of attorney can be very complex and nuanced. It's not just a case of whom do you trust, because if you didn't trust your son, your daughter, your spouse, you would not have them within 1 mile of the power of attorney for property. But how are they structured? I've got 2 daughters and a spouse. Do I have all 3 of them act? Do I have them all act at the same time? Do I have my spouse first and then my daughter and then my son? Do I have my spouse by herself and then my daughter and son working as a team? What if they don't agree? All of these kinds of structural things, which are critical, are needed to be built into your power of attorney. I know you're all going to say, oh, the family's nice and they'll all get along. Well, my kids are nice too, but they don't always agree on everything all the time. For serious issues about timing of the sale of a home or what to do with investments or things like that, there can be differences of opinion. Differences of opinion are okay, but differences of opinion that lead to disputes and friction is not okay. So, careful structure, choice and structuring of your attorneys. There's a whole gamut of things that we go through, everything from geographic proximity to capability of the potential attorney, to their ability to work nicely with others, to their abilities to do the types of jobs they might have to do. If I'm a business person and if I need, one of the things that my attorney might have to do is to keep my business running until I recover, or get it organized for sale if I don't recover. That's going to be quite a different set of skills than perhaps my spouse has, who's perfectly capable of renewing the investments and dealing with the checks. Operation is another very important aspect of it. How many of you here have the financial type of power of attorney? Not many. Now, let me check that again. How many wanted the government to get involved? If you have a period of incompetency, because the other 12 of you that didn't put your hand up should be putting your hand up now. That's what you're voting for if you don't have the power of attorney for property. Those of you that do have a power of attorney for property probably have what I call a blank check power of attorney. Without realizing it, without intending it, you almost certainly signed a document, however long ago, that took effect at the moment that you signed it, and with no conditions or restrictions. And therefore, most of you, without intending it, or probably even realizing it, have signed over full authority of all of your legal and financial affairs to other people right now, while you were mentally capable. And you're going to say, oh, but that's not what I meant. I only wanted to have one that took effect so that people could help me if I couldn't do it myself. And I'm here to say that's probably not what you signed. You probably signed one that takes effect immediately. Then some of you might say, oh yes, but I trust my children and I trust my spouse. But it's not a trust issue, it's a purpose issue. How many of you would want your children to make the decision as to where you live, because they're convinced that at 50 they know more than you at 80 about what's good for you? And the answer is no. While we're capable, we would like to make our own decisions, thank you very much. And so my response is, then why would you provide for a document that says otherwise? And all that's doing is leaving the door open for a perfectly well-intentioned child to say, I know better than mom. She's living all by herself. She could fall down the stairs. I don't know where she got her stubborn streak from. So I'm listing and selling her house. And I was authorized 8 years ago to do so. Okay? So my recommendation on the financial power of attorney is that you have, most people, 90% of my clients have what I call triggered or programmed powers of attorneys. They take effect when you want them to take effect. So typically it would say, while I'm capable, I retain full independent control of my own affairs. Thank you very much. Any family member that wants to have a chat with me or try to persuade me of something is most welcome to, but if I decide otherwise, nobody can go around me and outvote me. Stage 2, if a doctor certified that I'm no longer mentally capable, right, after a stroke or Alzheimer's or something, that written document then triggers the power of attorney, it takes effect, the government is kept out, no one goes to court, and my spouse, or whoever my number 1 person is then authorized to do everything that needs to be done until I recover. And then I certainly would recommend a 3rd stage, which is to say, and if I'm not mentally capable and a doctor has confirmed that in writing and my spouse died the year before, then it's still not government or courts, it's my child or children or whomever the backup person is. Now, I could go on and on, but I won't, because I do want to tell you about powers of attorneys for personal care. I'm almost afraid to ask this. How many people have not a living will, not a healthcare directive, but a document that says power of attorney for personal care right at the front? Hey, that's pretty good. Not very good, maybe. And 1 minute, So power of attorney for personal care does 3 good things. It identifies the people authorized to consent to medical treatment on your behalf when you can't speak for yourself. It makes medical decisions for you that relieves others of the responsibility. For example, pull the plug if I'm on life support and there's no hope of recovery. Please, please, please don't use stupid things like no life support. If you need a bypass operation, you will have to be on life support, and if you have said on your legally binding document no life support, you've just signed a suicide note. So that's not what we want. It makes medical decisions. So number 1 advantage is that it authorizes people to consent on your behalf, typically family members, and again, very careful structuring. Here, absolutely. There's all sorts of pitfalls in the structures of all things. Get careful structuring of the power of attorney. You can say both kids, or what if one's not available in a medical emergency and your document says it takes 2 to decide, right? There's a very careful structure. I have one that I think works. I think it's the only one that really works, a sort of a hierarchy of names, but nevertheless, a lot of attention needs to be paid to the structuring of your attorneys. A lot of the stupid powers of attorneys for personal care that you have right now, ladies and gentlemen, that put your hands up, says, my spouse is an authorized person, but if she's unable or unwilling or dead or been removed by the court, then it's another kid. Well, what if she just doesn't answer the phone? Wouldn't it be nice to have the kid authorized? But you're probably don't. I've already mentioned very careful, if your power of attorney for personal care has stupid phrases like no heroic measures and things like that, toss it out and run to your lawyer. It says no life support, rip it up right on the spot. And then most importantly from the power of, oh, hi Steve. Most importantly from the power of attorney for personal care side is distribution of the document. Being in the hospital emergency room, unable to speak for yourself, needing to consent, having a beautiful document that has beautifully trained or organized people that are able to respond, but you can't speak for yourself, your kids aren't there, your family isn't there, they don't know there's a problem, and so of what use is your power of attorney for personal care? So my recommendation for my clients is I have them sign up 3 copies. I keep one in case other copies are lost or mislaid. There's one at home for their own reference. There's a 3rd copy that goes to their family doctor to be kept with their health records, which turns up sooner or later, hopefully sooner if there's a medical emergency. And I provide them with an emergency contact card that they attach to their health card, Leslie, that says, if there's a medical emergency, I have a power of attorney for personal care. Here's the name of my attorneys. Here's the phone number for my attorney. Here's the order to call them. And oh, there's my doctor's name and phone number where you can find my health records if it matters what the cardiologist said in their report. This, of course, in any emergency room in the land will come forward within 2 minutes of your arrival, and therefore within minutes they will know that you've got a power of attorney for personal care, who the attorneys are, what order to call them, and that gets the people involved that need to be involved quickly. It gets the consents flowing that need to flow quickly. And then, as mentioned, there's access. It's not so much your doctor we care about, he or she isn't needed in the emergency room, but the emergency room physicians may need quick access to your healthcare records in order to know whether you're on a blood thinner like Coumadin before they give you a blockbuster and kill you dead.
Any questions?
Yes, sir.
Are handwritten wills legal?
Yeah, they are just fine. They're called holograph wills. You can do them yourself if they're entirely in your own handwriting. You can't word process them and sign them. They have to be entirely in your own handwriting. They do not need to be witnessed, and they are a lawyer's favorite kind of will. Because instead of charging you a couple of $100 to do a proper will, we'll charge you tens of thousands of dollars in estate litigation afterwards. Seriously. People screw them up. Even if you buy those forms from Chicago, Illinois, from the United Stationers, they're probably not, they may work just between husband and wife, but no will works between husband and wife. After that, they start failing and they don't provide protection for the children against marriage breakdown, separation, divorces. Please don't do a holograph will. It's not a responsible thing to do.
Can you mark up an existing written will?
You can, but it won't work.
Why not?
Because wills are very formal documents. They must be witnessed, they must be signed. There's an affidavit that has to go along with that. Simply taking an existing will, which is properly done, and then making changes to it and initialing it does not meet the statutory requirements for the formality of a will. So your will work, but your changes won't work.
If you have the changes witnessed?
Yeah, then what you should be doing is a separate document called a codicil, which is an amending document to the will.
And that can be handwritten?
Yep. And then you don't need witnesses. The handwritten ones don't need witnesses. Any other questions? I just thumbed the ball into silence, so back to you.
Thank you.
Very good.
Now, Peter mentioned an anniversary date, and one of the roles that the council has taken on is we've created Make a Will Week in Peterborough. And it's the first week in June, and we hang a banner over George Street. So at some point, hopefully over that week, you're driving up and down George Street, and that's your trigger to say, right, pull out the will, do I know where it is, have I got all those pieces in place? So if your anniversary date and whatnot goes by minimally, hopefully, we've done our job to say, take a look at your will this week. So next we have Stephen Bart. Stephen is a chartered accountant, and as well, he's also a former president of the Peterborough Estate Planning Council. He co-authored a book on estate planning for small and medium businesses, and he continues to be involved in the community through various organizations like the Red Cross, the Peterborough Executive Club, as well as right now he's assisting me at Trent University with our Legacy campaign in our community division. So, welcome, Steve.
Thank you. Have you ever heard of a lawyer that didn't talk? Well, they told me I could have the rest of the hour, and I'm going to ask questions at the end of it. Now, did everybody's stress level go up?
Yeah.
Okay. First of all, Dave, I'm going to be relatively quick. I've subtitled my topic, Stress Relief for Your Estate Plan. Because face it, when people walk into my office to have an ordinary personal tax return done, they're not paying Jennifer and I because we know what box to put the number in. I mean, a gorilla could do a tax return. Yes and no, but you know what I mean, okay? They're paying us for stress relief. Steve Bart, Chartered Accountants, did a tax return, and the tax guys probably aren't going to pay much attention to it because they think it's going to be right. And besides that, I suppose they're also saying, Steve or Jennifer, here's all my junk. I don't want to deal with it until you call me in a week and a half and it's done. Okay? That's what they're really paying for. The same thing more or less applies to what you're doing here. In the seniors forum last week, Gord happened to mention get organized. So he may do it again today. I'm not going to do that in detail, and I'm not going to do it the way he did it. He had some good steps to do. I'm going to say do the result of getting organized. It'll help you quantify your situation. And there's a lot of relief in knowing exactly where you are. Gee, what banks did I have again? I know I'm at so-and-so and so-and-so, but I used to have an account at such and such, and I wonder whether my daughter knows I've got them there. Okay, so you want people to know where you are. If you can quantify your problem, it's a help. It may be a problem, but quantifying it, and now at least you can deal with it. If my staff knew on April the 5th that we got a whole pile of tax returns to do, and thou shalt April 30th or not, you know the way the rules work, they're going to be pretty stressed out. But if they know they have to do 14 tax returns a day, which is a lot of work, but now they know 14 and I go home and it'll all be okay. We'll finish on time. Well, hello there. See, it doesn't like me at all. You want to make your tax affairs flexible, but you want it to be predictable. There's a real help in being predictable so that the people that are charged with looking after your estate, as well as you for the last 30 years of your life, renders it relatively predictable. And just as a bit of boring stuff for how your tax or how your estate works, when you die, there is a final tax return being prepared for you. It's prepared like a normal tax return, but only up to the date of your death. After that time, especially if you're the second of the spouses to die, there probably is going to be at least one more, and it's called a T3. It's an estate tax return. And the reason for that is it's taking a while to wrap your estate up. I mean, all your shares may have to be sold, or they may have to be re-registered. The cottage may have to be re-registered. The deed to this and that may have to be changed, let alone the tax department are delaying, sometimes reasonably so, the assessment of your tax returns. If I was doing an estate tax return right now, and I filed it on Friday, the tax return may not even look at it till January of next year, because they're afraid if the current government brings a budget down, then it won't be assessed under 2013 rules. So there is often a delay in getting it done, but generally that's the format. So you're helping your executors get your affairs in order and be organized to generally if you understand how it does work. Now, the situation of tax for a deceased taxpayer. There is no estate tax in Canada. I've said this at every seminar I've been. I wonder if I've said it enough that people are starting to get it, because I just said there's no estate tax, but there kind of is. Okay? We love to badmouth them in Florida when they say there's estate tax, but we kind of do. That is to say, you're deemed to dispose of everything you own the instant before you die. If your spouse survives you, okay. He or she will step into your shoes with everything you own, although there are some games the accountant can legitimately play to reduce her ultimate tax or his ultimate tax. Okay, but generally speaking, we'll talk about the second of spouses or a single person that dies. They're deemed to dispose of everything they own. There might be some pretty significant capital gains in some of the stuff you own, and there will be some tax on that if you haven't taken care of it. Your GIC, your term deposit, I mean, $10,000 term deposit is worth $10,000, $10,000, $10,000. No problem there. You're only paying tax on the interest that goes along. But how about shares you have in GE, or Scotiabank, or Bombardier? You're a brave soul. I like airplanes, but well. How about your house and your cottage? Maybe there's a principal residence involved. Maybe there isn't. And how about your art? That is a taxable transaction. Personal use properties, what your art and your jewelry, and up till recently, the accountants had just said personal effects, $5,000. No tax effect. That may be changing. That may be changing, where in fact there's more regulation. We're going to have to start looking at that kind of thing. So you may have a gain there. Also, do you realize that all your RIFs or RRSPs come into income in that final tax year? Okay, you got $250,000 in your RRSP and RIF, you didn't do any planning about it, and all of a sudden your final tax return, the government's basically going to take 46% of it. Okay? Can planning help? Well, I think it probably can. And don't forget, you're deemed to have sold everything, but you haven't sold a darn thing. Where's the cash going to come from to pay for the tax, if there is any? I can see planning coming on, and I can see that nasty word, insurance, coming on. Insurance is good stuff, people. Okay? There's one of the uses for your insurance is to pay the tax that can't be sheltered when you die. Best planning, all aside. You might do other things with your investment advisor. My guy is saying to me, Steve, we have your plan ready, and your RRSPs, your risks will be drawn down first. So one hopes I live to be a healthy and old age. And we're going to draw down my RRSPs, RIFs first, so then I'll be drawing down my unsheltered investments. So when I die, I hope my kids and my spouse get more, not less. Which brings up the next point. I suppose you know there's 3 beneficiaries to your estate. There's 2 you want, and 1 you really don't want. Okay, and I've seen Pete do this before, you know. How many people want government to be one of the beneficiaries to your will? And they are. They're a charity like any other. The only difference is you don't have any say in how they're going to spend your money. Okay? You want to designate your families and your charities. Okay? So, and by the way, while you're thinking of it, we all want to live forever. And one of the ways you could do that is a legacy donation. And when you talk to your lawyer, I think lawyers these days are getting strong enough, confident enough that they could be something of a salesman for the hospital, for Trent, for Sir Sanford Fleming, whatever you so choose. And you can live forever through a legacy. And government, by the way, are making tremendous benefits to the tax-effective charities because government are getting out of that business with the shortage of cash. I can't go into detail. We'd be here for hours and hours and hours. By the way, I'm glad to hear Mr. Lillico say he also recommends July the 1st, Canada Day, for being the day you look at your will, because for the first time in years, he told me years ago, Steve, pull out your will on April Fool's Day and have a look at it to make sure it's right. And to this day, I didn't know whether he was making a fool of me, which may be hard to do, or whether it's a great idea. Make a fool of yourself. Pull your own will out and have a peek at it. But I think I'll stick with April 1st because there's a good fool. Have a peek at yourself. By the way, you also, every time I sit in a seminar piece, and I've been to many of them, I get scared every time because of the traps that are involved in powers of attorneys and will. You know, does your power of attorney have the ability to change them? Like he said, when you're incapacitated, it's too late. Okay? And I also love when lawyers joke, and I believe them, damn it. Gee, I hate to say good things about lawyers, but here I go, number 2. If you want to do the will kit, the lawyers, in fact, are going to love it. Because my father was a litigation lawyer, not in that angle of litigation, mind you, but they got to just love it because there's going to be more arguments than you can shake a stick at. Okay? Pay something, have it done right, and have it followed up on. Wills are critical. You want to designate the beneficiaries that you want and in the way you want. Because, of course, we've always heard that fair and equal aren't all the same. Peter has a whole business that deals with cottage succession for his clients. Because my grandparents started a cottage up in the Severn River, and they had 4 kids. And those 4 kids had 4,000 kids, give or take. And my generation had 8 million kids, give or take. Okay, who is going to get the cottage the next time around? Well, the daughter that lives in Vancouver, you might think, okay, that's easy, no problem at all. Obviously, Jennifer can't get the cottage. She lives in Vancouver. Okay, but what if the cottage is in Muskoka and it's worth $3 million? And the rest that parents have are $100,000 of investments. Bit of inequity there, and yet maybe it's fair. I don't know. So you got a problem. You want to kind of think ahead of those things. I would rather my kids get along. I suppose when I'm gone, I won't know it, but I really would rather they get along. Human nature's funny that way, isn't it? And the other thing, you want to set the circumstances of their inheritance. If one of my kids who are now majors, there are none of them that are young, very young, you might want to set some conditions on them. So if my daughter inherited through a testamentary trust, until such time as she was 28 or 29, there'd be a trustee, one of which, say, is my brother, looking over her shoulder. Because I can tell you, if I had a son and he inherited some money from me when he was 18, what's the first thing he's going to do? Buy a car. And it ain't going to be a gut box, it's going to be a bright red Camaro. You know, so you want to set the circumstances. And the final consideration I have for you is, we're talking about estate planning, and people hate that estate planning. Damn, I'm dead. Okay? you guys are gonna live to your 85, or my mother's 87. She's over in Ireland doing a bus tour. Damn it, I hope she's not behind the wheel. Okay? You're gonna be healthy for years and years. Have you structured your affairs to maximize the income while you're living to maintain a standard of living? Now, no doubt about it, Mom doesn't need the income that she might have needed when she was 73 and 74, but she still doesn't want to have to worry about staying where she's staying as long as she so chooses and is able to, feeding herself, having entertainment, going to Niagara on the Lake a couple of times a year to the Shaw, if that's what she does. Okay? So you want to be sure your affairs are structured while you are living. And again, consider how they're to be allocated. How are your final taxes going to be paid? There's a big deal. Until relatively recently, insurance has been kind of a dirty word. Take advantage of the expertise your insurance guy has and that your investment guy has. I had once said to me about 5 years ago, I read an article that said, how much time have you spent on yourself in the last week for your investments? Well, none. Okay, in the month. Well, I looked at the statement when I came in. How much time, Steve, do you spend on your investments in the last year? Half an hour. How much time do I spend on your guys' taxes? Hours and hours and hours. So what the heck am I doing? So the idea was I went over and got a guy I really liked, and I want that guy across my desk 4 times a year with my statements and say, Steve, this quarter I did nothing and I don't think I'm going to for a while yet. Or I did this and this and this, and this is the reason why. And I've had to revise your cash position until age 85 because of so-and-so. There, now somebody's doing the job for me. Okay? Part of what Peter, the implicit message of what he was saying is, if you have to pay someone to get it done right, jeez, it's worth it. I really think so. So that's basically what I have to say. That's what I want you to know. Do it though. And again, the will is the cornerstone of what you have to do. Could I take any questions if there are?
Quick question. If you have money in a TFSA and I pass a law, does that money become taxable in my estate or does it remain?
In your estate, tax-free savings account is exactly what it sounds like. It is outside the tax system. If you're the last of you and your spouse to die, any income after that time, only the income after that time becomes taxable. Furthermore, that can roll over to your spouse and become hers and keep going. Now, your spouse is still limited to that annual amount of contribution if they're still making it. So there's the short answer. Good question, short answer.
On cottage succession and presumably taxes paid on the capital gain on the cottage, can the cottage be deemed principal residence?
Yes, it can. Yes, it can. Choose.
Pardon?
Choose.
And
What's
prorated.
going to be, your house or your cottage? You can
And
pick one or the
presumably
other.
you prorated for the years you owned it.
That's right. Well, that's what I didn't want to answer because that gets complicated. Principal residence rules are actually pretty darn simple. I don't know which of my house and cottage are my principal residence right now. As long as I'm in one place for 24 hours, it's my principal residence. My principal residence could be in Timmins,
I
where
guess
my
that-
cottage is, for all you know. It's after you sell it, or when you're about to sell it, you decide, am I going to designate those years that I own the cottage? Which of those years am I going to designate? And you get a fraction that produces the capital gain. Sure.
Legal term of spouse.
Oh, there isn't such a thing. There's a definition under the Family Law Act that defines spouse to be, well, one definition is married spouse. Then they have a definition for common law spouse. The definition for common law spouse is cohabiting for at least 3 years unless there's a child born, in which case it's 1 year. Canada Pension has a different definition of spouse. There are any number of legal definitions of spouse.
The short answer is, in the old days, like everything else, it used to be easy.
Right.
A separated spouse can be a spouse, not a divorced spouse.
Thank you, and by the way, if you have any questions that we don't have time for, don't be afraid to call the office. It's a lot more fun doing this kind of stuff than it is corporate tax returns and auditing. Thank you.
Good.
Thanks. Our next speaker is a tag team between Gord and Linda. Gord Fallen is a senior wealth manager with Scotia McLeod. He's a fellow of the Securities Institute. He's a certified investment manager a certified financial planner, a chartered strategic wealth professional, and Gord is also highly involved in our community through Rotary. He's also a past chair of the Peterborough State Planning Council. He's past chair of 5 Counties Centre Foundation. He's past president of Kawartha, and was also involved with Sir Sanford Fleming College. So thank you, Gord. And maybe I'll introduce Linda since I've got the floor for a second, and then you can do your. Linda is a financial consultant with Scotia Private Client Group, which is the wealth management division of Scotiabank. She's a certified financial planner who has designation as a retirement specialist. She specializes in financial planning using a holistic approach which encompasses clients' financial, investment, retirement, tax, and estate planning. So you can see how we've brought the best here in our community to speak with you today.
Thanks very much, Sherry. Kind words, greatly appreciated. Obviously, financial matters is a very broad topic, so we're going to narrow it down to a few areas of concern. First off, I'd just like to welcome you here, and you've made the first step. One of the biggest concepts is about estate planning is actually doing the planning. So you're here, you're making that effort. I commend you for doing that. Too often we don't dedicate enough time. When you want to do estate planning is when you're healthy, you're happy, everything is good. You can give good thought to the process and carry on from there. The other side is that you're going to probably notice that as an estate planning council, we do work together. I do a lot of work with accountants, with lawyers, and back and forth, and also with charities, because estate planning involves all components, and we need to work together. So some of the things that I'm going to talk about, you may have heard bits from others, but that's because we all work together. But first off, I really want to say is one of the things that as far as a plan goes, is that we should prepare a list of assets and where they are and who to contact. One of the things that some people don't do is that they know where everything is, they know what they do, but we can all be fragile when it comes to things, and that's why we're doing planning ahead of time. That's why we do estate planning ahead of time. We can bad things can happen to us at any time. We're fragile. We can fall on the curb and bump our head. It doesn't have to be serious. But one of the things that too often people don't have things written down, compiled. It's a simple process. You should share it with someone, but some people want to stay very private. And if you do, that's fine. But maybe have it somewhere accessible for someone to get to, that if they need to know where bank accounts are, where investment accounts are, where your real estate is. You may have ownership in properties. You may have investments in small business. But if you have a list of everything and where it is, then someone can actually help to manage that if that comes into process. And that may come into process A at your death, if that be the case, or it may through powers of attorney if something happens, and that's where those things are very important. So I just want to make sure that if you can keep a list, keep it up to date, look at it periodically, make sure that it's okay. You're going to make it better for someone else that's going to try to help. Wrong way. The next topic I want to touch on before Linda comes up is about life insurance. Now, life insurance is a broad topic. Not everyone likes to hear about it, but it can be used as a very good tool in estate planning. One of the things with life insurance is it's very important, perhaps if you have young children and obligations that you need to meet. It's great. We hope we never pull on it at that time, but that's when you have to have it. But the life insurance strategies that I'm going to talk about are tools that can be used in the estate planning process. It can solve some of the problems, dilemmas that can come through from people's estates and where things are. So I'm going to talk to that a little bit. I guess the caveat though with life insurance is One of the way that it works is it's risk insurance is really what you're buying. And you do need to, there are factors involved, and one of them is your age, and the other is health. So those are things that are very important if you're looking at any life insurance strategies. And therefore, sometimes it's better to look at it earlier on than waiting to be too late, because you may not qualify for a life insurance company to insure you. But areas and strategies where life insurance can be particularly useful in estate planning comes into a few different areas. I'm just going to touch on a few, and one is legacy. It is one way to leverage your assets to leave a larger legacy. The legacy may be to your family, it may be to children, grandchildren, but it also may involve a charity that you feel strongly about that can help, whether it's health or education or religion, to help fill a need. So having that involved in your estate plan can be a very, very important aspect. Another aspect that in my practice I deal with some people that have gone through a second marriage and maybe have children from a first marriage. Sometimes maybe even 3 or 4 marriages, but the one thing is that if you do have that and you're now venturing on another part of your life with a new spouse, and we start to do estate planning, most people, or that I come across, want to do something for their children when they ultimately pass away. They want inheritance to go that way. It can be much more complicated with second marriages. So one solution, or could be a solution, is to use life insurance to provide that legacy for your own children, that inheritance side of it, and sort of separate the two so that your second spouse isn't compromised if something should happen. So it's a tool that can be used in there to mitigate any problems that could happen, and also eliminate. Sometimes I have seen it where maybe there's a real estate, a house involved, where my spouse could live in the house for the rest of her life, and then it goes off to children. But that can cause a great rift between those children and the person that's living in the house, doesn't want to give it up. There are different things that people come up with, but sometimes maybe just the financial consideration can solve that. And that pool of capital can come from a life insurance policy. It's one aspect. Another aspect that where life insurance can be a very good tool in estate planning, and Steve touched on it with cottages or real estate, that your principal residence in Canada so far as I know so far, is not taxed on your passing. But other real estate holdings, whether it be a cottage or rental properties, will be deemed to be sold at the time of death, and capital gains can be involved. And they can be, a large pool of capital can be required for Canada Revenue Agency at that time. And sometimes there's just not that pool of capital available. Another solution can be is to use life insurance. Life insurance geared to the amount of money that would be due for the tax. It can sometimes keep a cottage in a family if that's the required. That's what succession plan is, because it satisfies Canada Revenue Agency in that time. It is a way to make sure the capital's there. Now, of course, to have life insurance, you have to qualify, and you're going to have to pay the premiums to have that end result. But it is a way to have that large amount available. So it can be used for different reasons. And but also probably a third avenue can be very important is for charitable gifts. And we often have causes that are very important to us, and to be philanthropic is very kind. By using life insurance, we may be able to take a more modest amount of money that we're going to pay in premiums to a life insurance company, for ultimately to have a substantial gift to go to the charity. And that's It's something that, that has to be in your mind and your wishes. But another topic that Steve talked about was, again, coming back to this, but when you pass, everything is deemed to be sold at the moment of death as far as Canada Revenue Agency is concerned. When you're dealing with registered plans, whether it be an RSP or a RIF, that can be an issue. It can be a substantial amount of money that we would see payable to Revenue Canada. They feel it's fair because these funds have never been taxed. When the money goes in, it's not taxed. When it grows in there, it's not taxed. It's supposed to be taxed when it comes out. If it all comes out at one time, it could be at the top tax bracket. But there are different strategies that can be employed, and again, we're going to use life insurance as a tool. One of the other components is that in the year of your death, you can use charitable receipts to deduct your total income. Now, your total income would be quite a bit higher if you had a registered plan have to collapse. So what you can do is, again, pre-thinking, you have to have this in a plan. If you have life insurance that would be for a substantial amount of money because of your registered investments, you could designate the charity as a beneficiary. So when you pass, the charity gets a large legacy, and with that, they will issue a tax receipt back to the estate. Now, what you can do is use that large tax receipt to offset the income that would be coming out of, that would be normally going off to Canada Revenue Agency. So what ends up happening is, with that type of strategy, and of course, mind you, you have to be charitable minded, but if that be the case, the charity gets a great gift. Your heirs will be handled under your will, so they will have perhaps the full complement of the registered funds. And Canada Revenue Agency is left out in the cold. So this is something that our governments have developed, that charitable giving, to encourage that. We do have charitable tax receipts which can do that. But these are strategies that can be determined, but they have to be determined ahead of time. And when you're planning, it's something to consider. A lot of people like the fact that a charity can get a great benefit, that Canada Revenue Agency gets sort of shortchanged on the deal. The other side is it goes on to a great legacy. It has to be pre-planned, and it can be a great tax planning tool as well as estate planning. So don't run away from life insurance when you're looking at estate planning. It can be a useful tool, depending, and you need to talk with a financial consultant to find out maybe where it fits in your own personal ideas and thoughts. And with that, I'm going to turn this over to Linda, who will detail a little bit further.
Great, thanks, Gord.
Thanks, Linda. Okay, sorry.
Wait.
Gord had touched on life insurance. As a financial consultant, I deal with a lot of individuals when it comes to my clients' needs and wishes. And, we talked about the Peterborough Estate Planning Council and how we work as a team. One of the things, because I'm not a licensed life person, that I pull from the team of experts within the council. And just to give you an idea of another way, people look at estate planning as, I need lots of wealth, it's only for the rich and the famous. It's not, it's for everyone. And quite often you'll see husband and wife where there might be a difference of opinion, and that's where life insurance can also play a role. I had a situation where there was a client where her idea was everything was to go to the children. His idea was, I have a charity that I'd like to benefit. Okay? So we used life insurance because he was donating to the charity on a monthly basis anyway. So he saw a gift at the end. She saw the gift going to the kids. We were able to convert the monthly amount he was given to charity into a life insurance policy, so he wasn't any more out of the pocket. But we were able to then leave the legacy gift by having the life insurance, so everybody was happy. So again, talk to your planners, and there's lots of strategies can be put in place. So what I want to talk about is from a financial point of view. A lot of people will go to the, I guess, bother or the headaches of getting their stuff together, but then they keep it very secretive. I'm not here to tell you that you need to share what you have with your family, but the more you can get each other involved, because I see a lot of clients where one of them looks after the finances. If you were to look at your family finances, there's very few people that I see in this room, and I probably, if you could show me your hands, how many both jointly look after the finances? Okay, way to go, Steve. Because
Maybe I'm henpecked.
typically,
I doubt that.
I mean, I work in the financial industry, so my husband says, you know what, you just do this, I leave it to you. I said, well, what if something happens to me? Where will you turn? Well, I go to the bank. Well, the bank doesn't understand. I mean, the bank is there, they understand, you know, what's happening in your bank accounts, but they don't know your intentions, they don't necessarily know, you know, what you have at other institutions. So you need to start by sharing that information with your spouse to start with. Never mind the next generation at this point. Make sure your spouse is aware of what's happening. Make those thorough lists. Sit down and have those conversations as to what's happening. Where do the bills get paid? Do we pay rent? Do we have rent coming in? What utility bills are coming where? Make those lists. Because if you become incapacitated, the power of attorney is great to have, but they need to know what to do. So find out where these different things are coming out of. What do they want for a funeral? Because it's not an easy topic. We have Comstock Funeral Home is also on the Peterborough State Planning Council. And I know they have lots of people coming in, what we call at need, when somebody's passed away and having to deal with that. One of the best things you can do is pre-arrange that, have that dealt with. But have those conversations with your family. Because I think what Steve mentioned about needing money right at the time of death, well, the funeral bill needs to be paid fairly quickly. So what arrangements have you got in place to make sure that funeral bill can be paid and the family's not stressed trying to figure out how to come up with the money to give you the memorial that you deserve? Bank accounts and credit cards. We see people running in all the time looking at, okay, I want to make my kids joint on my bank account. If you walk away with one thing here today, joint ownership works well in first marriages with spouses, but beyond that, there's lots of complications because you're giving them a blank check, you're giving them access to your bank account, you're opening your bank accounts up to their creditors as well. And you know, if there's separation with your kids separate, 50% of marriages are ending in divorce according to statistics. You know, you want to be able to have somebody have access. The power of attorney can do that while you're living. And then things like the funeral bill, if you haven't got it prepaid, the banks, for the majority of them, will let that bill go through upon your death if the executors bring it in. Mortgages and credit cards. People look at putting mortgage insurance on their mortgage, and yeah, that may pay it off, but till that all gets settled, those payments still have to be made. Okay? So who's taking care of the mortgage? Who's securing the property? And again, if you become incapacitated, who's going to step into your shoes and do those things that you've taken care of? Because you know all of your finances, but somebody else can't just pick up the ball and do it like you have. Your investments, insurance policies. How does that all fit in with everything? The insurance policies pay out fairly quickly, but not sometimes quick enough to get those bills paid at death. So how do you have things arranged? Sit with your financial advisor. Let them know you have concerns. What can I do to set my stuff up ahead of time that there'll be money there to pay things if something were to happen to me? What have I got in place now? And okay, I talked about joint ownership and how it affects, but how does the assets and the ownership of your assets fit in with the rest of your estate plan? So you go to the lawyer, you have your plans done and your wills put in place. And then you go to the bank after and somebody talks to you about a strategy. Think of those strategies and how does it fit in with your estate plan. So if you're looking at naming beneficiaries on your RSPs, if your spouse is no longer living and you want to designate a new beneficiary on your tax-free savings account, how does that all fit in with the overall estate plan that you have? We talked earlier about having, you know, the fairness and equal on your will. So if you have your designated beneficiaries on your RSPs, your tax-free savings accounts, your life insurance, that bypasses your estate. So what effect does that have on your overall? I've seen clients say, well, I'll leave the cottage to my daughter and my son can have my RSPs. The RSPs, as we heard from Steve, is a taxable event. The cottage could be a taxable event. The principal residence may not be a taxable event. So you think you're leaving things of equal value, but the taxation comes in and then affects it. So look at your ownership and how that's structured. When it comes to your principal residence, the other thing I've had people say is, well, I'll put my children on my principal residence and I'll void the probate. Probate's the lesser of the evil because you've now just taken your principal residence and it's no longer the children's principal residence, and if on title, then you're triggering taxes that are unnecessary. So probate can be the lesser of the evils. So that's kind of my part, just open it up for questions for Gord or I. No? Other questions?
I got a question. You were talking about insurance,
Yep.
right?
Yes.
So the premiums I'm paying are earned income. Can I avoid tax on those by buying the policies?
By buying the policies?
Yeah, I mean,
If
so
you-
because I'm buying the insurance policy for the future, because
Right.
that premium,
If,
which is coming out of my earned income, can that be?
It is. If you make a charity, the beneficiary, you're revocable. The owner. Yeah, the owner of the policy, then your premiums are considered tax receipt. Charitable tax receipt.
So they're a charitable donation right there.
Yes.
Otherwise, the insurance is with, you're buying insurance with after-tax money.
Dollars, yeah.
Yeah.
You're getting the benefit at the end.
Now, but the other side though too is that your estate will not get the tax receipt at your time of death.
That's right.
You know, if you're looking for, you can't have it both ways, I guess is really what they're still limiting, so. But for some people, that can be a great advantage, is getting it along the path, you know, depending where you are, if your income is close to a clawback or something like that, it can be a way to reduce.
That would not apply to an insurance policy designated to your grandchild or something like that, would it?
No,
It
no.
can't be regarded as a charity.
Not that I'm aware of.
What about the last one you mentioned where there's you get a tax receipt back, you get a receipt back from
Yes, if you
that's not 100% of that though. Surely you can't claim 100% of that.
In the year of death, you can.
Yeah, you're just in your year of death. So that's when the other large portion of income comes in, say a registered plan collapse, whether it's a RSP or a RIP, then that can offset that.
Because normally you get percentage, say a political
Yeah,
donation.
you do,
get 75.
but in your year of death and previous year,
Yeah,
it can be up to
75%.
100%. So that's where it can come in handy that way. But again, you would have to pay the premiums without tax benefit to get the large benefit
Right.
at the end, if that's the case.
Any other questions?
Any other questions? Thank you very much.
Thank you.
That was great. I don't know if you're getting the idea here that it's all about planning, isn't it? Once it's triggered, we're done, you know, the plan's in place. So there's so many little important facts about this plan. So, our next speaker is Jennifer Curitan. She's from the Peterborough Regional Hospital Foundation. She's the manager of Legacy and Annual Giving. Jen has worked very closely to make sure that there's great care at our hospital, and whenever we need it, we want to make sure there's great care, and we know there's great nurses and doctors and support staff there. She's worked there for 8 years, helping out with the donors who help make that possible. Jen's a volunteer as president of the board for the YWCA, and has served there for 7 years. She has 2 young children, so she's a busy working mom, and she loves to ride her bike and spend her time in the great outdoors here in Peterborough. So welcome, Jen.
The first thing I just want to say is that, you know, I know why we don't have plans and why people like to postpone them, because talking about death is not the most exciting thing. But the one thing I do want to say is that your estate plan and the legacy that you will leave and how you'll be remembered by your family and friends and the community at large, it's life-driven, only death-activated. So we're not really talking about death, I don't think. We're talking about our lives and what they mean to us and what we want to be remembered for. And so when you're doing all of the important things that my colleagues here have talked about, just try to remember that, and that's why it's so important for you to do it, because it is really about the life that you've led, and it's how you'll be remembered, and how easy that will be for people, or what a pain in the butt it will be. You know, as a charity representative, we try to work really closely with donors, but we also want to work closely with your advisors, because while we want to have as much funds available to fund the causes that we all care so deeply about, we want those gifts to mean a lot to you. We want them to be things that you can be passionate about during your life and that people can remember you for. And the best way to do that is to work together. And so this little diagram is something that I always reference, and it's just this sort of triangle of how we can work together. Your vision for the future, whatever that may be, is what we all want to help make possible. So if you share that with your advisor, they'll be able to assess your situation to say, oh, you might need insurance here, or you need to put a bequest in your will, or you need to you know, get this will situated like this and that. That's what they will be able to do based on what your vision is. You'll be able to say, okay, so that's great, but what about this other part? My family, my friends, the charities that I care about. If you involve the charities, we can also work with you and with your advisors to say, oh, okay, that's the best kind of gift for you, the best tool that you need to use. That's wonderful. How can we use that gift? How do you want it to be implemented? What kind of good do you want to create with this? And by working and sharing that information with us, we can make it the best for you that's possible. A couple little points I just want to touch on here is that there are various tax benefits, as everyone has talked about, of giving. There are many benefits during your life and at passing. So during your life, you can use a charitable tax credit for the year that you make your gift, or for up to 4 years in the future, so for 5 total years. And that's at 75%. But if you make a gift at the time of death, it can be used for that year and your final estate tax return, and it's at 100%. So those are the kinds of things that you would talk to about your advisor. So maybe you have a tax problem during your life as well, and you need to help manage that and mitigate that, in which case you can actually make a charitable gift and see it in action, get the feedback from the charity to say, yeah, this is something I'm feeling good about this, you know, I'm happy about how this gift was used this year, and maybe I will do something in my will, or maybe I will do something for the future, because I'm really confident that it's going to be used how I want it, and my wishes will be respected. By far, the most common type of gift that charities receive in this sort of legacy sphere or planned gift are bequests. Bequests they're a little bit easier than other kinds of gifts, and that I think tends to be one of the main reasons why. It's not as complicated. And bequests are really for everyone. This is a picture of a donor, and you know, she said, a bequest is allowing me to make a gift I never thought I could afford. She's lived a very modest life, really community involved, really community minded, but just, you know, makes small regular donations to the charities that matter to her, and never thought she could really do much more. And then her lawyer introduced her to the concept of a bequest, and she chose her charities, and there she goes. She's feeling really great about this impact she'll make in the future, and it's the charities that she'll benefit will be able to do a lot with that. But so why do people do it anyway? You know, the things that I find is that maybe they want to give back to the community. Maybe they want to say thank you for something, care or an education or something else. A lot of people say because it's the right thing to do. And those people typically have their church in there, and then maybe a couple other charities too, and it's something that, it's a value that you hold. Making gifts not possible during your lifetime, like I mentioned. And then also another really interesting thing I hear sometimes is reflecting my values. And I've heard someone describe it as, I want to teach my children and my grandchildren one last life lesson. And that life lesson is to share and to give. And if you have, to share that and to make the world a better place. And I just thought that was a really neat thing to be passing on. And so they're going to share that, at the family picnic or whatever with their family and just talk about, this is what I'm doing and why it's important. I hope maybe that will be important to you one day too. So there's so many different ways. Bequests, though, like I said, are the most common. Always consult your advisors and you'll help to create the best situation for yourself. A specific bequest is essentially where you say, I bequeath X dollars to charity ABC. There's many benefits to that. You'll know exactly how much you're going to leave. And you can sort of position it that it's the right amount of a gift that you want to make. But there are also some drawbacks. What if you spend the last 10 years of your life at Royal Gardens or in a home that's quite expensive, and maybe that $20,000 was actually a much bigger share of your estate than you intended? And I actually find that residual bequests are the most common, and that's where you say 10% will go to this charity, 10% will go to this charity, and 10% will go to this charity. The other 70% will go to my heirs. And so that's more common, I would say. Would you say so, Peter?
No.
No? Okay.
Most of my clients would do a specific bequest and then review it.
Right.
And then they've got very predictable tax stuff.
Right, and that's to Peter's point as well. So you are reviewing it so that it's not all of a sudden, oh no, I can't afford to give $20,000. But nonetheless, ones that I see most tend to be the residual. And then contingent bequests as well provide for changing circumstances. So it could be left to a spouse if you pass first, but then to a charity after that. So there's just a variety of kinds of bequests. One of the other real benefits, I think, is that it's revocable. So you're giving to this charity during your life, they're making good use of your gifts, you're really happy with the impact that it's making on the cause that you care about. But let's say they don't, and let's say they're not making an impact that you care about, and let's say they're not reporting back to you. Well, you can take it out. So you can change your mind. And I think that's an important thing because it's the legacy and it's what you'll leave, and it's totally in your control. And like I mentioned as well, it can be an expression of your values, what was important to you. We talked about insurance quite a bit, so I'm not going to go into it too much more, except to say a couple really brief things, and that's just to clarify a couple things that we've said. So you can do a gift through insurance a couple of ways. The first thing is you can establish a new insurance policy that lists the charity as the owner and beneficiary, and that allows you to contribute your yearly premiums, and you'll get tax-deductible receipts for the amounts of those premiums. Or, if you have an existing policy, you can transfer the ownership. You can, if it's fully paid, then you'll get a receipt for the cash surrender value and any accumulated interest or dividends. Or you can, if premiums are still payable, you can make the charity the irrevocable owner and beneficiary and receive the premiums for the tax receipts for the rest of the premiums. Or you can name the charity as the owner of the policy and make a bequest for the value of the policy. And in this way you can still access the money if your circumstances change, but the charity will receive the tax-free proceeds and your estate will be eligible to claim the tax donation receipt. So there's many different ways that you can structure it to benefit you and solve the particular challenges that you have, and also to make a wonderful gift. There are also gifts like endowments, and many of you are probably quite familiar with endowments, but what they are essentially is a pool of funds that are permanently set aside and they're invested, and they generate an annual dependable source of income that can be used for the charitable purposes that you care about. Expenditures are made from the earnings while your principal remains intact, so it really is a gift that lasts forever. And because they're held in perpetuity, your charity will benefit for so many years to come, pretty much forever, unless the charity needed to use it or something for some purpose. But when I think of an endowment, I think of these two people, and there's someone who set up an endowment, and there are a lot of really great benefits. It lets you support the cause for the long term. you have some control over how the money is used. So for these two individuals, for example, the woman, her name is Tina, and her father passed away from a heart attack at a really young age. And so she thought, and her husband thought, you know, there's so many advances, and there will be so many more advances in cardiovascular care. We want to invest in those kinds of things. So they came and said, yeah, we want to do that. And so I said, well, okay, what exactly do you want to invest in? Well, I don't know. So we brought in the cardiologist, and they were able to sit and talk and have this great conversation. But the point is that they were able to be more connected, more deeply to the cause that they care about. And so whatever the cause may be, when you set up an endowment, you help to define what the purpose will be for the future. If you're setting up a new one or contributing to an existing one. But you really get to be connected and honor someone. And in this case, they were honoring Tina's grandfather. And it was just a wonderful way for them to express their gratitude and talk about the future and the way that they hope that they might be able to impact the future and be remembered in some way as well. The charity, the advantage to the charity is, well, we know about endowments, so we can plan on their use, and we can start benefiting the people that we all serve right away. The charity gets a chance to work with you and understand what means a lot to you, and make sure that we use the gift how you want. And the charity has a chance to involve you in the activities. So in this case, the gift was that much richer for these individuals because now every year they get an update about how the funds are being used, how the investment's going. Cardiologists might call them to say, hey, this is what's new in cardiology today, and just thought you might be interested to know. And it makes a gift so much richer. One of the things I see often is that we don't often know about a gift until someone's passed. And, you know, it's a private matter. Absolutely, we understand that. But we just really want to do a couple things, and one of them is say thanks. And the other is to be able to use it how you intended. This is a donor who didn't tell us about their intentions. His name is Stefan Hollis. And, but luckily he told his lawyer. And so when we did receive his gift, we were able to do what he wanted to do, to be done with that. And so we built a courtyard in his case. And that was really important to him. So at least he let someone know. But we never got to say thanks. We never got to show him along the way how this courtyard was becoming a reality and the planning that was going into it, and so that he could have that input. So those are kind of some of the things that I think about when I do get to talk to a donor and get to thank them and say, oh, okay, let's sit down. You know, your request might not say something specific that you want to happen, but maybe we can have a conversation and I can just understand what's important to you so that a long time from now, when the gift is realized long enough into the future, that someone will be able to make sure that what you wanted happens. When you are talking about and thinking about making a charitable gift a part of your estate plan, I'd say to talk to the charities. That would be my advice, but you know, absolutely it's a private matter. At least talk to someone about it. Ask a lot of questions. Make sure you get the legal name correct so that we can use the gift when we receive it. Talk to your lawyer about any special clauses. Sometimes with charities, if you have a really specific purpose outlined in your will, my favorite one is to talk about, you know, wills that say, and bequests that say, use this to advance cancer care. Well, what if cancer's cured in 30 years? Wouldn't that be fantastic? Let's hope that it is, and let's hope that we have a lot of problems with wills in 30 years. But sometimes there can be a special clause that your lawyer could put in there so that if cancer is cured, your gift can go to the next most important thing. And if you actually sat down and had a talk with the charity, we know, oh, heart disease is next most important to you, so yeah, we don't do cancer anymore, but we do still look after hearts. So, you know, we can make sure that your gift is used exactly how you intended. And like I said, talk to the charity. This is all a little bit of a repetition. The only thing I would point out in here that's additional and why you might want to consider sharing your intent is that we want to offer you the opportunity to be recognized, but of course we also want to offer you the opportunity for complete anonymity, and we will respect either of your wishes. If you decide to share your story, you can inspire others. You could be like Griffin Tina Lloyd, who said, yeah, sure, tell people. Maybe they'll give to my endowment too, and we can grow it. You know, I think what I started with was saying that, you know, your legacy and your estate plan is life-driven and only death-activated. Please do it. If you didn't raise your hand to all Peter's questions, get all those little ducks in a row, and Gord's questions and Steve's questions, get all those little ducks in a row so that you feel really good about it. You have that stress relief taken care of that Steve talked about, and enjoy it and share it with people and be proud of it. It's really exciting, so thank you. Any questions for Jennifer? Yes?
You mentioned the revocation possibilities of a charity.
Yes?
If you don't like the charity, you can pull your money out.
If it's a bequest? Yeah, absolutely. You change your will.
So if you have a charity and then you lose your capacity to run your financial affairs, can your power of attorney revoke?
I don't know.
Can't on a will. If you, one of the things that an attorney under the power of attorney for property, in fact, the only thing expressed in the legislation that you cannot do is to change a will. But then that is also extended to other testamentary dispositions. So arguably changing if I designated a charity on a life insurance policy to be effective on my death, probably can't change that with the power of attorney either.
They cannot change.
Cannot.
So the power of attorney, they can't change the will either.
They absolutely cannot change the will.
Right.
I think there's a concern of a lot of ill practice that could go on there too.
So they can't change, even though they know there's something wrong in terms of the direction that the institution's taken or something.
It's too late.
Yeah.
If the person didn't do it themselves while mentally capable, then they've lost their opportunity,
Yeah,
which is
okay.
why you review.
Right.
Yeah, it's a good point for review, absolutely. Yes?
Can someone add a charity? So let's say power of attorney, you're on your deathbed, you say, I want to give $10,000.
Oh, sorry, an attorney for property can make a charitable donation while they're alive in restricted circumstances, but they cannot change the will to add a charity on to a bequest in the will.
Okay, the proceeds from an estate, they can take a portion of that and donate it to the charity.
No. Once they're dead, the will makes it all graven in stone, and that can't be varied from. Prior to death, there is some flexibility for an attorney to make charitable donations.
For example, if someone was, gave $1,000 every year to their favorite charity but couldn't make that decision because they were incapable, then the power of attorney would be able to carry that out, because you knew there was a history of that as well, and you knew that it might be in line with their wishes. Any other questions? Yeah. Oh, sorry.
Hi.
Hi.
I have a will.
Yeah.
And I think the lawyer that I had has passed away. So does that change anything?
The most important thing that I would say to you is, it'd be nice to know where your original will is.
Yes, I know where it is.
You have the original will, or you know where it is, and
I have copies.
copies don't count. You should know where the original will is, and there's an affidavit of witness that should go with that. It's probably gone to whoever took over that lawyer's practice. So, but you shouldn't say, well, it probably is there. You should track it down.
Okay.
And if it's been so long and you're not even sure if the lawyer's alive, then I'm saying you need to revisit that will anyway.
So if that's the case, if I retrieve it, then I can take that to the new lawyer and he can...
Sure, but you don't need to go to that trouble. If you're going to look at your will, you could go to a new lawyer, you could bring in the copy that you have.
Okay.
Your new lawyer can say, hey, it's fine the way it is, let's go get it. And by the way, I happen to know where Joe Smith's wills are. Or alternatively, this is obsolete anyway, we're going to do a new will, that revokes the previous one, and we'll keep better track of the new signed will.
So I like the way you do things, so are you busy?
This is what I do all the time. I'd be happy to see you, and all of my clients, you're welcome to come in and talk to me, and I'll give recommendations, and it's only if you choose to proceed that you get a bill.
Do you have a card?
Yes, I probably. No.
Any
question? Go ahead.
I'm not sure where I'm saying this, but it's about financial management. I have a bank, the bank has people who give financial advice. Is that as good as having an outside financial manager?
Let me answer that because I got no conflict of interest. Your bank will give you good financial advice. Your bank's financial advice will always, the person giving that advice will always be looking for opportunities for the bank to do business. So I can almost guarantee you, if you walk in and say, I've inherited $200,000 from my parents, what do I do with it? I'm almost certain that it will be a bank product that you get the recommendation. And it may be a perfectly good recommendation. I highly recommend, though, for a couple of reasons, that you would also get an independent person, somebody not doing your investments presently. Now, Scotia actually has a whole program of let us give you your second opinion, which they offer without charge, but many of the financial advisors would be happy to do that. You just need to specify up front to them, please look at this. It doesn't mean I'm going to transport all of my business over to you. The other thing that can happen with financial people or lawyers or anybody is, when is the last time your bank took a fresh look at things rather than, oh, well, she's coming in, oh, these are pretty good. Not a critical look, and you get that from a second hand.
Right. But still within banking, is it better to have somebody who has no connections to banking?
No, you want somebody with qualifications. Now, Gord, one of the that Gord has that I'm familiar with is CFP.
Yeah.
So there are independent CFPs, there are CFPs that work for banks, there's CFPs that work for Scotia McLeod. It's the qualification of the person that you want. So much then every financial person will be affiliated with some financial institutions one way or the other. But it's the qualification of the person that you're needing to know. I didn't mean to steal your thunder. If you guys have additional advice, go for it.
Yeah, because at the bank level, no matter what bank it is, they have certain qualifications, but, you know, it's three hopes that the bank can deal with if they realize, you know, you need advice beyond what the capability is at the branch level. Like Scotiabank, the branches bring me in to say, okay, these clients need additional planning, and then I'll do the planning. It may not even be a Scotiabank product that we recommend, because we don't work at the branch level, which you'll find with a lot at the branch level. That's what they do. They have their products, as Peter said, that they would recommend. But even at the branch level now, it's expanding. What the banks do, I guess, bring to you is you've got that stability of the bank behind you. Right? But it's a lot more broader than it used to be.
Thank you, that's very helpful.
Second question.
Where do you keep your will? I mean, the copy of the will, what is the best place?
Where do I keep my will?
Anybody else?
I keep my will in a vault. What I offer my clients, and I think this is probably typical for most of the lawyers in Peterborough, is when we do the will, the client owns the will. It's their property. What I always offer my client is, I will keep your will in my vault at no charge indefinitely. If you move to Windsor, you should come by and sign it out at the system. But it's safe and secure in my vault. Not all lawyers agree with me. They don't always want to take responsibility for it. But I've been at the other end too much. When somebody comes in, mother has died, all I've got is a photocopy of the will. The lawyer that did the will is dead and gone, and then we have a copy of a will. Judges don't like will copies. You need to probate it, as most people do. So that's my recommendation. Number two would be some other place safe and secure, not like your dresser drawer, but perhaps a safety deposit box. Then the trick is making sure that the family knows that it's there and has access to it. And they don't get access to it by having a power of attorney, because you're dead. They get access to it by being a joint owner on that safety deposit box, which gives them access to it. Then the last level would be someplace safe at home, like a fireproof box or something like that. And once again, if the family don't, if your executor doesn't know where it is and have the key to get access to it, it's pretty useless. Does that help?
Yeah.
Great, any final parting questions? I don't mean that, however.
Oh, bad.
Oh, yeah.
Sorry. Well, thank you you for joining us today. I hope it's been a provocative, thought-provoking conversation with our experts. I really thank them for sharing their expertise today and thanking you for joining us.
Would you like us to do this again next year, a similar thing?
Yes.
Would this be something else?
I think it's very,
Okay, because what we did was this sort of grew out of the senior showcase, which some people went to. We thought, this is good, we should double the benefits, so we'll try to come up with different topics for next time.
thank you, Pam.